Hi, I'm Tristan, and this is Thinking About Politics. So today, we're still fighting the Arizona Fraudit. You see, American democracy depends on our honest pursuit of the truth. And there are so many lies out there about supposed election insecurity, especially in the 2020 presidential election. And we're looking into these allegations to try to see if they actually hold any water. And if you want to be part of the fight for facts, democracy, and decency, go ahead and hit the thumbs up and give us a subscribe. Feel free to share this video with a friend. We sure would appreciate it. So we've just read the 3 legitimate audit reports that were produced for the Maricopa County Elections Board. And all 3 of these audits, 1 hand recount and 2 audits of the machines in the election network, came up with no evidence of any fraud. One of our friends commented that we should check out some of the court cases that were brought in Arizona a little bit deeper. So we went ahead and did just that. Today we're going to start with Bauer V Ducey. This is a case where 14 Republicans sued the Republican governor and the Democratic Arizona Secretary of State, asking them to quote, decertify the 2020 general election. You know, this really is a gold mine of stuff. We're talking about an affidavit from a former guard to Hugo Chavez, a statistical analysis of a multi-state phone survey to determine that illegal votes were cast for Joe Biden. You know, stuff like that. We can take our time and really pick through this stuff and take small bite-sized chunks out of this. There's a lot there. But for this episode, we thought we'd want to give like a high-level overview of what this case was and how it was decided. Let's go ahead and start with like a little bit of a lawsuit 101, shall we? And while we're talking lawsuits, let me just mention that nothing I'm saying is legal advice. This is just sort of fun educational content here, okay? So first off, this case is a civil case. Now, a civil case is usually when a person decides to go and sue someone else or the government for some wrong, or some harm that they've suffered. And this is different than a criminal case, and that's when the government comes after you for breaking the law in a serious way. And in a civil lawsuit such as this one, it all kicks off with something called the complaint. The complaint is a piece of paper that states your issue and what you want done about it. What you do is you take that piece of paper and you chuck it at the person that you want to sue, and you also chuck it at the court where you want to sue the person. If you've thrown that paper just right, that person's going to have to come into court and answer the complaint or the allegations that you've raised. But if you haven't brought like a real claim, the court might just go ahead and throw out your lawsuit right then and there. So what do I mean by real claim? Well, I had a professor explain it this way to me. A real claim is like this. So you walk into the store and you buy one of those pre-wrapped fruit pies. So you open that pre-packaged fruit pie and you mow down into it, and instead of just gooey goodness, you bite into a thumbtack. Now, tacking the pie? That's a real case. We don't know how the tack got there. There's a lot of information we still need. But we know a few things. The pie was prepackaged. It was probably wrapped at a factory someplace before it got to the store. The tack probably got into it before it was wrapped. I mean, unless there was a big tear in the package or something like that. And also, biting into a fruit pie only to get a mouthful of thumbtack? Well, it's going to ruin anybody's day. There's some harm there. From a lawyer's perspective, that's a great case. Real claim. What's not a real claim? What's not a real claim is this. You get into the elevator with your coworker Sally, and she didn't smile at you today. You think Sally's really stuck up, and the reason she's being mean to you now is because you really did better than her at the last group meeting. On top of that, you think her not smiling is just an attempt to get other people to think you're like mean or something. So, no smile Sally? It's a terrible case. Not a real case. We got no idea why Sally didn't smile at you or what's going on there. But we do know a few things. One is, Sally's under no duty to smile at you. Although you're guessing at her motives, you don't really know. And no matter what you're feeling, it's really between you and your therapist. The law is going to give you no relief here. Real talk. Whether or not you bring a real claim, what happens next is that the attorney says, the other side hasn't brought a real claim. Throw out the lawsuit. But if you get past that first motion to dismiss, that first time somebody comes in and says, hey, judge, throw this case out, well, the other side has to answer your complaint. They need to either admit or deny the facts that are contained in the complaint. You can get some more information that way. So in law, the rules that govern this whole back and forth when different documents can get filed and thrown at each other is set forth in what's called the Rules of Civil Procedure. And because law is a profession that tries to make itself unnecessarily complex, every single state has its own rules of civil procedure. And the federal courts as well have their own federal rules of civil procedure. There are rules that cover what's got to go in a complaint, how you got to chuck it at the opposing party, what courts are the right courts to throw it at, and there are rules that say the court can go ahead and toss your case for being a no-smile Sally rather than a real tack in the pie. There are two specific rules that are going to be important for this opinion here, and I think you should know about them ahead of time. As always, there will be citations in our description with links so you can do your own research as well. So normally that first piece of paper that gets thrown, the complaint, it's covered by Rule 8. But when you're going to accuse someone of fraud, you also have to watch out for Rule 9. See, Rule 9, subsection B, says that in alleging fraud or mistake, a party must state with particularity the circumstances constituting fraud or mistake. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. So when you're going to allege fraud, you have to allege that somebody did something knowingly or maliciously, that they knew they were engaging in fraud. And there's another rule I want to point you to here, and this one is called Rule 12. Subparagraph B in Rule 12 gives the court a bunch of reasons why they can throw out a case. So look at this. Numbers 2, 3, and 7, well, they kind of have to do with throwing the complaint at the wrong people, right? Whether that person is the person you wanted to sue or the wrong court. Like throwing the paper to the wrong place. Numbers 4 and 5 are kind of like saying you threw the paper wrong. Like you threw the paper, but there's no way it was going to get to the right person so that they would know ahead of time that they had to do something. And numbers 1 and 6, well, those are your no-smile Sallies. Again, generally speaking, and relevant to this discussion. So let's go ahead and take a closer look at the complaint by these 14 Republicans and try to guess whether this is a true tack in the pie or a no-smile Sally. To start with, who are our parties here? Who's doing the throwing? Well, the plaintiffs, that's the people throwing the paper in the first place, are a bunch of different Republicans, as I said. 3 are GOP county chairs, and 11 are Republican presidential electors. And they're throwing their complaint at the defendant, who happens to be the Republican governor of the state of Arizona, as well as the Democratic Secretary of State. They're the folks who already certified the 2020 general election. Well, it's generally not relevant who the attorneys are. I should point out that in this case, the attorney for the plaintiffs is the Trump attorney Sidney Powell. She's launched many lawsuits across the country with similar allegations. Not normally relevant, but kind of interesting here. So in the very first sentence of the complaint, you can see that the plaintiffs are alleging fraud. The second paragraph says that the fraud they're alleging is old-fashioned ballot stuffing, updated for the digital age. That has now been amplified and rendered virtually invisible by computer software created and run by domestic and foreign actors for that very purpose. So they're saying that the computer software used in the Arizona election was created for the purpose of rendering invisible ballot stuffing. That's a big claim. But right away, we're in Rule 9b territory. The paragraph deals with alleging fraud. And if you don't believe me, check out paragraph 44 of the complaint. It claims that it lays out, quote, specific factual allegations of fraud, end quote. And remember, Rule 9b tells us a party must state with particularity the circumstances constituting fraud or mistake. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. So you probably have to allege that the defendants here, 2 state officials, one a Republican, one a Democrat, knew about this fraud or otherwise acted maliciously with regards to it, right? And even if you're just filing suit against these officials because you want them to decertify an election, which I don't even know if that's possible, not because you thought they were guilty of the fraud themselves, I think you still need to allege with particularity who was doing the fraud, right? You can't just say that fraud existed somewhere, maybe. But here's really where you start to hit your first big speed bump. The complaint claims that there were problems with signature verification. It complains that 2 of the poll referees were members of the Independence Party. It makes allegations that some folks had interactions with elections officials and technicians that they didn't like in one degree or another. But none of it alleges actual fraud, though. Definitely not on the part of these state officials anyway, and not on any other identifiable party. And then they introduce some very questionable analysis from a purported expert. And I say it's very questionable because he claims that out of a telephone survey asking people about their absentee ballot status that occurred over multiple states, not even targeted to Arizona or Maricopa County, that somehow there's a statistical analysis that shows that the numbers that folks got were weird, or that really the numbers should have been higher for Trump for some reason. So again, that numbers look funny is not an allegation of fraud. I'm not a statistician, but I really question the use of a multi-state study to figure out like the vote totals in a single state. And then the claim is that the voting machines are expressly made for the purposes of allowing people to change votes, and that it's vulnerable to hacking. That seems like two different things to me, but okay, whatever. There's no allegation that Governor Ducey or the Arizona Secretary of State did anything, and the evidence that they're using, some of it is anecdotal evidence from partisan poll watchers, that why they were connecting all these very minor occurrences with Governor Ducey and voting machines that have no use but for fraud. I mean, these seem like dots that really need connecting here. But, read the complaint and ask yourself, what harm have these people bringing the lawsuit faced? Have they got a tack in the pie, or is this a no smile Sally? But let's crack on and talk very briefly about the opinion. So the court opinion starts by remarking upon the really remarkable ask the plaintiffs are asking here. They call it extraordinary. The plaintiffs are asking the court to set aside the votes of over 3 million Arizona voters. The court notes that such a request should then be accompanied by clear and conclusive facts to support the alleged egregious range of conduct in Maricopa County and other Arizona counties at the direction of Arizona state officials. Yet, however, the complaint's allegations are sorely wanting of relevant or reliable evidence. So, the judge is saying that there's no possible evidence that the plaintiffs have pointed to that's going to allow them to prove a fraud case. Now, let's just pick this apart. The court that's read all this evidence is saying that it's either not relevant, which means if it's true, it really doesn't matter to the case of fraud, or it's not reliable, which means, yeah, it might matter to the case of fraud, but it's like information that's hard to trust. So what did the court do? Well, they flushed this thing entirely. After the plaintiffs threw that first piece of paper, the defendants asked the court to dismiss. And the court agreed. They said that the allegations were so off the wall and incoherent, the court had to conclude that this was not a case of tack in the pie. This was a full no smile Sally. But tune in again next time. We're going to get into a little bit deeper into the ruling and ask, was this a technicality? And is it possible that there are still merits to this case? And I think you'll see when we read together that even though this court does not reach the merits, they were not impressed with the potential evidence put forth by the plaintiffs. But that's it for me. Thank you for watching. Leave us a comment below. Let us know what you think. And, until next time, keep thinking.
Kiss you now, I'm busy with this mule.